Section 230 in its current form is no longer working.
This law needs to be updated so that it continues to work well.
I think that Congress should update the law to make sure that it's working as intended.
These recent incidents are only the latest in a long trail of censorship and suppression of conservative voices on the internet. Reasonable observers are left to wonder whether big tech firms are obstructing the flow of information to benefit one political ideology or agenda.
Facebook is profiting off and amplifying disinformation that harms others because it's profitable. This isn't a speech issue.
I, for one, think we should be considering taking away the exemption that they cannot be sued for knowingly engaged on in promoting something that's not true.
The big tech oligarchs have declared war on the Republican Party and conservatives. I think it's time that we consider the outright repeal of Section 230.
In 1996, Congress passed the Communications Decency Act, and within it, Section 230, the piece of federal statute that has allowed the internet to exist as it currently does. Now, lately there have been a lot of conversations about big tech regulation and online content moderation, but a lot of these conversations conflate antitrust regulations and First Amendment issues with Section 230 as a scapegoat. Now, to better understand some of these conversations, I sat down with Adi Robertson, a senior reporter at The Verge who covers, among other things, Section 230 reforms, to get a feel for where this conversation really should be happening and why we don't understand Section 230 as well as we should. Now, before I play that interview, I want to take a look at two things. The first and second portion of Section 230 itself, a relatively short statute. The first section states the following.
No provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider.
And the second section states this.
Companies that operate in good faith have the power to restrict access to material that they consider to be objectionable, whether or not such material is constitutionally protected.
Now, on its face value, this is not a super complicated piece of legislation. It allows the internet to exist and for people to moderate. But that's not where the conversation around Section 230 is headed recently. And so, I was very thankful of Adi to donate some of her time to have this conversation with me and better explain how we should talk about regulation and the internet. I guess just starting with the basics in very broad strokes, you just kind of explain what Section 230 is and what the intent behind it was.
The heart of Section 230 is really simple, and it's that if you are a user or operator of an interactive computer service, whether that's a website or an app or something else, and someone else posts something on that service, you can't be treated as the publisher or speaker of that content. So if they post something illegal, you can't get sued over it, is the upshot of the rule. It gets a little more complicated. There are exceptions to it, especially with some recent amendments. But the basic idea is that it's a liability shield that grew out of some problems that occurred when web portals like AOL and CompuServe and Prodigy were growing in the 1990s. And courts started making decisions that were basically punishing websites and services for moderating content. So there wasn't really a great analog to what a web portal was. It was like maybe kind of like a bookstore or kind of like a newspaper. And courts had started slowly coming down on the idea that if you just let people post whatever they wanted on your service, then you didn't really have any expectation to know what was on there. And if somebody posted something illegal, you weren't responsible for it. But if you did moderation, like if you wanted to run a family-friendly service, then you were responsible. And so you were basically going to get penalized for trying to make your service a nicer place to be. And so in the mid-90s, Representative Chris Cox and Senator Ron Wyden got together and they wrote Section 230. And the goal of it is to let sites moderate without taking responsibility for the content that's posted on it. And then over the years, there have been court decisions that have interpreted this really broadly. And so at this point, it's just a really sort of all-purpose rule that has become very integral into how the web works.
So just to clarify a few points on that, you're saying that we can't hold anybody who's the information service provider liable for things that are illegal. that doesn't exempt people who do the actual posting, correct?
Right. So if you post, a really simple way to think about this is if you're Twitter and one of your users posts a defamatory tweet that's just a horrible lie about someone, that person can sue the person who posted the original tweet, but you can't sue Twitter. However, if Twitter did put out like a blog post or an official tweet and it was saying something defamatory, then you could sue Twitter because it would produce the speech. And there are exceptions to this, like I said. There are special rules for copyrighted material, for piracy, and you can bring a federal criminal prosecution against a site, and Section 230 isn't going to protect it. And as of 2018, the SESTA FOSTA bill means that anything that's related to sex trafficking isn't protected by Section 230. But for a large part, yeah, the goal is that if somebody does something bad online, you go after that person, you don't go after the service that they use.
So right there, we kind of mentioned the idea of a lot of defamation issues, child pornography, sex trafficking, and that had kind of been the heart of 230 for a lot of the time. But since 2016, a lot of the conversation around some of that has kind of shifted to regulating the types of speech that the largest platforms are able to distribute and the role that they have in that. How is somebody like a Facebook or a Twitter protected by 230 with how they operate as a platform, as a news media aggregate?
So weirdly, a lot of the actual good faith debate over Section 230 hasn't really changed. There's still a huge conflict over, say, how liable you should hold a site if it facilitates harassment, or if it basically exists for people to post non-consensual pornography. A lot of the really central issues are still there, but we've gotten into this really bizarre situation where people rely on people think that websites are protected by 230 for posting and hosting just like content that's legal, but that people don't like. Like most misinformation at this point is not, at least as far as most courts have decided, it is not illegal. Like you can lie on the internet, and that's not content that somebody could sue Facebook for and win, even if there wasn't Section 230. So there's been this really strange conflation of Section 230 with the First Amendment on one hand. And then on the other hand, there have been a group of people, basically Republicans, who argue pretty much the exact opposite of the original goal of Section 230. And they're saying that, well, the problem is that Section 230 lets sites moderate too much, and it lets them kick people off. So we're going to pare back Section 230 so that will make them too scared to kick off Nazis or people that we think they should not have kicked off.
So right now, if you're Twitter and you're deciding how much you want to moderate your platform, you currently don't have the legislators putting in action legislation that's going to tell you how much you should or should not regulate within your own platform. If that's the case, why haven't Twitter and Facebook and Reddit decided to take a more aggressive approach to doing moderation?
Oh, I think Facebook and Twitter moderate a bunch. So the problem with something like Facebook is that no matter how much they moderate, they have billions of users, and it is virtually impossible for them to catch all of the content that is bad on the site. And the flip side of this is that they also constantly take down content that doesn't break their rules. Like, they're just, by definition, given their size, probably going to make a ton of errors, and that's going to give the impression that they moderate less than they do. Twitter is kind of emblematic of just a general Silicon Valley ethos that for a long time, this was kind of a point of pride, was that they were, quote, the free speech wing of the free speech party, that there was this ideological commitment to not moderating any more than necessary. And Twitter and Reddit have both moved away from that in recent years. But at this point, yes, Section 230 has allowed them to moderate, and they have honestly gone pretty far with moderation in a lot of cases. The problem is just that I'm not sure there is a great way to moderate at scale. That once something is so big that you have just giant call centers full of people constantly trying to decide whether something breaks their rules, there's just no way to moderate in a way that's going to please everybody.
And then you also get into just the human cost of doing all of that, right? Like some Casey Newton's reporting comes to mind, or just the human cost of sitting through and going through every single flag piece of content on something like Facebook.
Right. Yeah. I think people get this idea that content moderation there's this really complex bill of rights and people pore over it like a lawyer every time they decide whether to take down a tweet. Whereas in reality, a lot of these decisions are automated. They're based on weird flagging systems that lots of people don't understand, even at the companies. Or there are people who are incredibly overworked, often really traumatized, and asked to make these split-second decisions to meet these incredibly onerous caseloads. And so it's not like they're a court. They're people who are trying to do their best in a situation where it's really easy to screw up. And I think that's kind of distinct from the normative view that Facebook is going to take from what it, in this like ideal infinite time world, would remove.
So we're talking about it's not a court. There is the recent instance, though, of Facebook setting up effectively a court. Can you talk a little bit about what the oversight board is, what it's doing, and if you see that as a potential avenue for other platforms to emulate moving forward?
Yeah, so the Facebook Oversight Board is an independent body, but a body that was funded by Facebook and is pretty strongly tied to them, that can review decisions. Like you said, it's kind of like a Supreme Court in some ways, except that it's voluntary, and Facebook says that it will follow the rules, but it's not like there's some kind of legally binding system. The Oversight Board is interesting because it basically is there to interpret Facebook policies in a way that isn't quite as closely tied to Facebook, and that sort of grants a legitimacy to those policies, is my read on it. I think that the issue is it's just not really a Section 230 thing. Like first of all, the vast majority of the cases that it's looked at so far have not been United States related. Like a lot of what it's dealing with is cases all over the world under completely different legal regimes. And second, a lot of the content isn't illegal. Like this is the problem with a bunch of Section 230 debate, is that if a thing isn't clearly illegal, it's not clear that changing 230 would actually mean anything for it. And at this point, what you're talking about is, should the First Amendment protect something? And that's just a completely different conversation, and one that I think especially a bunch of politicians are really hesitant to admit they're having.
So we're talking about different politicians trying to decide how to regulate big tech companies as far as antitrust regulation goes, how far the First Amendment applies to them. Who are some of the names to definitely keep in mind when looking at the conversations around technology companies in Section 230?
In terms of just general antitrust, Bernie Sanders and Elizabeth Warren have been pushing really hard for decisions that, while they're not necessarily 230 related, could have a big impact on tech platforms. Other than that, Amy Klobuchar and Mark Warner have both helped put forward some of the most good faith recent Section 230 legislation. Brian Schatz and John Thune put forward a bill last year that was sort of a bipartisan effort to create a good faith Section 230 reform bill. And then Senator Josh Hawley has brought a lot of bills, and he's made sort of one of his platforms being going after big tech. But those bills tend to be non-starters. They tend to be just really weird things, like he's going to try to ban infinite scrolling, or he's signing on to bills that other people are also co-sponsoring. So Hawley makes a bunch of noise, and I think that's worth taking into consideration, but his policy ideas tend to be pretty extreme. Folks like Amy Klobuchar have tended to put forward things that, while they would have a really big impact on platforms, are a little bit more grounded and at least a little bit more designed to solve problems that people are seriously talking about.
Grounded more because they aren't doing software solutions for the companies, or grounded because they build upon 230 to just close certain loopholes for liability?
So a bunch of Section 230 legislation from certain parts of the Republican Party is sort of aimed at just really indirectly trying to force companies to not moderate. So it's couched in this language of, we're going to try to make these companies be responsible, but the goal is just to sort of regulate and force these companies to keep users on without actually coming out and saying that. Amy Klobuchar and Mark Warner, who were two of the co-sponsors of one of the most recent bills, it's been really clear that at the very least, they're responding to specific conflicts that people have had involving Section 230. And they're like, we're going to make laws that will directly address those cases and that are going to make them turn out differently. And these things are clearly tied to Section 230. So the Safe Tech Act, which is one of the thing that they've proposed recently, one of the things it does is remove protections for, say, stalking and harassment, which would have maybe helped a case that was brought against Grindr a couple of years ago and that went up to the Supreme Court. That was a really classic, this site is, according to the person who's suing, enabling harassment, and Section 230 says that they're not responsible for this content.
So most of the cases revolving 230 have been at lower level courts and some have made it to federal district courts. But as of right now, the Supreme Court hasn't really given its opinion on what Section 230 really says, correct?
Right, because really there isn't that much judicial disagreement over what Section 230 means. It was really expansively interpreted. It was really expansively interpreted around the turn of the century. And from there, courts have basically just said, yeah, look, Section 230, it's pretty simple law, and it can be interpreted in a way that grants a lot of protection. There are a few caveats, but it's not a case where there's this really divisive split and the Supreme Court needs to come in and settle it. If you want to change something about the way that Section 230 works, the way to do that is in Congress.
So have there been platforms that have suggested ways that they'd be okay having Section 230 closed in a little bit?
Facebook is the company that has come out gunning for Section 230 reform. And its policy is basically, companies should be required to put out transparency reports that talk about all the content they've taken down. So people will at least understand why they moderate the way they do. This is, first of all, a little bit self-serving because it's something Facebook has done for a long time. Second of all, really not something that actually gets at many of the problems that people have with Section 230. And so it comes off as being kind of just a smokescreen for Facebook gets to say that they support Section 230 reform, but they're just doing it in the way that's going to be least troublesome for them. There are people who disagree with this. Everything I'm saying is kind of filtered through a really specific perspective. But there's a general understanding that, okay, maybe we'd be all right with a law that requires more transparency, but that's so that there won't be a much harsher law that makes us liable for a bunch of new content.
Is there a point to where you see Section 230 impacting some of the larger companies differently than some of the smaller companies, as somebody like Josh Hawley has mentioned, where you get to a certain size and you almost become lumped into a utility classification where the government does have more say over how you decide to moderate than a smaller something like Parler?
There are two kind of separate spheres that you have to talk about this in terms of. The first is what's actually good for people. And that after a certain size, is a company like Facebook big enough that the decisions they make impact people in a way that, say, they should be regulated more harshly, which is like a reasonable conversation to have. It would be really, really difficult to regulate Facebook like a utility. So even internet service providers are not regulated like utilities. Facebook is a company that what it does is arrange speech and put speech online. And at a certain point, you're going to run into really serious First Amendment questions with saying, okay, look, you have to carry really specific speech. There are plans, like there are people who've put forward ideas for how you could create some kind of utility style framework where Facebook has to carry things. But there's really not very much legal precedent for how we would do that. It is really difficult to really come up with a framework for either because Facebook just doesn't work like anything that we have regulated as a utility.
So we've been talking a lot about Twitter and Facebook just because those are the names that surface the most, but places like Wikipedia and even Reddit, though it's had its fair share of issues, seem to have pretty successful moderation issuances that different members of the community carry out themselves. Do you see different platforms needing to take more from each other, or is it just going to be the case that Facebook's going to outsource moderation to contractors and then Reddit's going to have a more hands-off, laissez-faire approach from the corporate level?
I think it's really hard to compare a bunch of these services because they just do completely different things at completely different scales. Facebook is the internet for a lot of people. Reddit is comparatively absolutely tiny. Wikipedia is not a social platform where people just produce reams and reams of text all day. It's a service where there's a discrete number of pages and people edit them. They're facing completely different issues. And if Section 230 is pared back, an approach like Reddit's actually becomes way harder, because at this point, if your moderators who are volunteers who don't necessarily operate the way you always want them to, if they don't do their job, then you're going to be liable as Reddit for everything that people say. And there's kind of a disincentive to take, you could call it a laissez-faire approach, but it's structured differently. Like Reddit's structured more like forums. And Facebook is structured like a dozen different gigantic services that are all lumped onto each other.
Yeah,
I think that
if nothing replaces it and Section 230 just disappears, what happens to the internet?
So the big question that we discover if Section 230 goes away tomorrow is, how much does the First Amendment cover what people put online? Like, what are the limits of what is legal and illegal? And how much are platforms protected by, say, the right to choose what speech goes on their website? That you're probably going to get a ton of bad faith lawsuits. And a bunch of the lawsuits are going to be about things that aren't actually illegal content. And so the sites are going to be okay, but it's going to be much harder to get those suits dismissed. And then the incentive there is kind of the thing it was in the 90s, which is if you think something's defamatory or you think something is harassment, then you're going to just take it offline and shut it down. So you get this kind of de facto heckler's veto, where if, say, a thing that people tend to talk about a lot online already is copy striking, where Section 230 doesn't protect a lot of like potential piracy. And so it's a lot it's a lot easier to be held liable for, say, pirated content on a site. So that's turned into this weird censorship tool where if you just complain about someone's channel, then the platforms are probably going to take that down because they want to be careful. Just imagine that, but way, way broader and way more complicated, and in a lot of ways, way more powerful. And imagine that a bunch of people who have terrible arguments and are acting completely in bad faith all try to deploy that against everybody they don't like.
And so if you're someone who's also concerned about larger corporations having more and more control of the internet, that would seem like your worst possible outcome, because those are going to be the corporations that can actually afford the legal fees and the moderation that goes with that, right? It's going to run small internet providers just out of the ability to keep up if they can't afford lawyers to handle some of those frivolous lawsuits.
That's definitely a thing that it's always hard for me to kind of predict how those things turn out, but there are definitely a lot of people who are very, very worried that the most powerful sites are the ones that would deal with a Section 230 carve out the best, especially because they can lobby to get their kind of preferred version of the bill that's easiest for them to deal with. And the only way that doesn't happen to me is if, say, it just is determined that a site like Facebook literally cannot exist because its liability is so great because it can't possibly check everything. That wouldn't happen really if you repealed 230, but you could maybe make some kind of bill that made it happen. But I think most of these people's goals are not to literally destroy Facebook. So yeah, the big tech is not really the people that you're hurting when you change Section 230. At least not hurting the most.
So you see continuing to carve more and more exceptions out of 230, a more realistic path forward than a full repeal of 230?
Oh yeah, it seems like there's a pretty high appetite to change Section 230 in some way. Again, it was really largely unchanged for a long time until Sesta Fosta a couple years ago. And that passed not quite unanimously, but with a huge majority. And it seems like at least one of the proposals that's going out now is probably going to somehow get passed into law. I think there are like a few specific things that are most likely to happen that are the most realistic. Like transparency reports seem like something that it's kind of easy, like that companies aren't going to lobby against very hard, and it's kind of easy to say you've done something and pass those. I think that it's also relatively plausible that you pass, there's a provision in the PACT Act from last year that says basically if you're notified that a court has determined something's illegal, you have to take it down within a certain period. And that's something that also, it's not going to strike at the heart of what a bunch of people are posting online, and it's one of the relatively workable options, although it has the kind of censorship potential that I had mentioned, and it's often not necessarily clear when something is illegal. But that's also one of the more limited changes. I think it's possible that you get more carve-outs like Sesta Fosta, where there's just a category of stuff that Section 230 doesn't apply to. The Safe Tech Act does that, although it does it in just an incredibly broad way. And I think that one of the interesting questions is going to be whether if there are bills that get passed, if they treat big sites and small ones differently. Like some of the bills that have gotten introduced, they are kind of designed to just be quote unquote big tech bills, where they say that if you're below a certain threshold, then these limitations don't apply to you. And they're just designed to say that companies the size of Twitter or Facebook have to deal with new restrictions.
Do you see the support in Congress for that mainly being along partisan lines, or is there some other determining factor that's a better predictor for how legislators and regulators kind of feel about some of these proposals?
So the plans to just pare back Section 230 protections for specific categories of stuff like stalking, those tend to be pretty bipartisan. That Sesta Fosta was also extremely bipartisan. Like you can definitely very easily get both parties on board with bills that pare back Section 230 protections for specific content that nobody likes. The thing that gets harder is that then there's this kind of additional Republican contingent that is trying to introduce bills that make it harder to moderate, which gets weird and paradoxical when you have the same people introducing things that it's going to make Facebook moderate both more and less. But I think that a lot of this has been really easy to make appear bipartisan so far because a bunch of these bills just haven't gone anywhere. I think that if we start getting something that looks like an omnibus Section 230 reform package, it's going to become, like you said, more partisan, because it's going to be a little bit clearer whether something is likely to make a site moderate more or less content.
And would you say that, I know he's been very big on it, but Biden's statement that he wants to change 230, is that more or less likely to actually drive any sort of changes within Congress in the next 4 years? Or is he just going to sit on the sidelines and wait to see what comes across the desk?
It certainly doesn't seem like a visible priority for Biden right now. I'm still really not clear on how much he's actually thought about this, because the example that he gave was of Facebook hosting what seems like totally legal misinformation, and so Section 230 repeal wouldn't change it. But I think that it suggests that if there's a Section 230 bill, that he's going to sign it pretty easily. But at least so far, it doesn't seem like he's pushing for any specific reforms. And I think the folks who are leading the charge here in Congress are their views are much more indicative of what we're going to end up getting.
Perfect. And if people want to follow some more coverage on these issues from you, where can they find you?
I am at theverge.com, and I publish stuff there, and my colleagues do too. And we also have a YouTube channel where I've got a video that explains a bunch of Section 230 weeds. And I've done an interview with Jeff Kosif, who is one of the authorities on this, that's also on our site. His book, The 26 Words That Created the Internet, is absolutely fantastic and a really interesting history of the law, and everybody should read it.
Well, I hope you all enjoyed that conversation as much as I did. I can't thank Adi enough for her time sitting down with me to discuss some of these important topics and kind of shape where the conversation around internet regulation is going to be headed for years to come. I also want to definitely recommend the same book by Jeff Kosseff that she did. Anybody who's interested, that should definitely be your first pickup if you want to be more informed on some of these issues. And definitely follow her on Twitter and continue reading The Verge for some of their great coverage on Section 230 and overall tech regulation. Thanks.